Okay, welcome to video 6 of the Florida MPJE Bootcamp. And as usual, we'll start with our disclaimer. This course is not affiliated with NABP, and I have no specific knowledge of the questions that are on the NABP. And don't forget that all the material in this course, the slides, video, and audio, is copyright protected and may not be recorded, reproduced, or stored without permission of the Florida Pharmacy Regulatory Advisors. All right, with that, we're going to continue in chapter 4, and we are on page 157. So in the last video, we covered the first part of chapter 4 were rules that were applicable to either pharmacists or to pharmacies and all types of permits. And here we're going to get to the specific rules for specific types of pharmacies. And I think the MPJE tries to be a practical exam, and realizing that most pharmacists practice in community pharmacy and institutional pharmacy, that's where you want to focus on, because you might get one question on nuclear, I guess, if you're unlucky. So there are other types of pharmacy practice, but they tend to focus on community pharmacy a lot, obviously, because that's where a lot of pharmacists work. So you want to pay particular attention to these rules. If you haven't worked in a community pharmacy, let's say you come from a hospital background, maybe spend a little bit more time on the community pharmacy rules. And if you've worked in a community pharmacy but you never worked in a hospital pharmacy, maybe spend a little bit more time on the institutional pharmacy rules. So just a little bit of common sense and advice there when you're studying for the MPJE. So like I said, I moved some of the rules into this section, even though they don't specifically say they're only for community pharmacies, just because it sounds like the way the rule is written, that's what they intended. So we talked, turning over to page 158, we talked earlier about terminology, and the Florida term for the PIC is really the prescription department manager. Well, this is the rule about the PDM, the prescription department manager, and make sure you read through it and make sure you know what they're responsible for, because they have the prescription department manager is responsible for the legal operation of the pharmacy, including maintaining all drug records, providing for security. When you are the PDM and something happens in your pharmacy, you can be held legally responsible for that. And we'll talk about that when we cover discipline in the next chapter. Don't take on the job of PDM without realizing the additional responsibilities you have. If a pharmacy technician diverts drugs out of your pharmacy, they could take action, and they will take action against the pharmacy technician, probably try to revoke their license. They could take action against the pharmacy's permit, the facility permit, for allowing that to happen, and also the prescription department manager for not having adequate controls to prevent the diversion of controlled substances. You didn't do the diversion, but you're responsible for the legal operation of that pharmacy. The basic rule on page 158 is you can only be the PDM of one pharmacy, but you can get an exception as is listed there in number 3. When you have a change in prescription department manager, you have to notify the Board of Pharmacy within 10 days, and that's number 5. And then there's a rule on the bottom of page 158 regarding daily operating hours and making sure that a pharmacy is actually going to commence operations or initiate operations and actually open the pharmacy. There's a lot of time frames in here, and the time frames always scare me because they're easy questions that they can put into the MPJE and make you put them in order and things like that. And we'll talk about, I have some summary charts for you at the end of the book to help with that. But there's a lot of these in this section, as you'll see. And what it says is if a pharmacy must have its prescription department open for a minimum of 20 hours per week. So you could have, let's say, a pharmacy within another store, a department store or a grocery store, something like that, and the store may be open 24 hours a day. It doesn't mean the pharmacy has to be open 24 hours a day, but the minimum amount of time is 20 hours per week. And then items 2 and 3 and 4 and 5, going over to page 159, are all about making sure you open the pharmacy. And my guess is they had a lot of issues with people getting their permits and not actually operating the pharmacy, because when they give you a permit, they expect that you are operating a pharmacy, and particularly a community pharmacy permit, and you're open to the public. You're not a closed door pharmacy. You're supposed to be open to the public. So What number 2 on the bottom, page 158 says is once you get your permit, you can notify the board within 14 days if you're going to delay opening the pharmacy. Let's say something happened and you can't open the pharmacy, you can't get your inventory in, or something's happened. You can do that, but you got to post a sign up, and they tell you how big the sign's got to be, and to let people know that this pharmacy is not basically not yet open. It's not commenced operations. And then when you do open the pharmacy and start operations, you got to notify the board of pharmacy within 2 days. And then number 5 gets in, if it's been more than 6 months, you got to provide a written notice to the board about, you know, what's causing this delay. How come you can't open this particular pharmacy? Number 7 is kind of an interesting one on page 159. If you're open 40 hours per week or more, you don't have to do this. But if you're not open 40 hours per week, you have to have your list of your daily operating hours posted on your pharmacy. I would think any pharmacy business would want to put, you know, these are the days we're open, these are the days we're closed, and operating hours. You want to put that on your, you know, at the facility and on your website too. Probably a good idea. But just so you know, it's mandatory if you're open less than 40 hours per week. The next rule on the bottom of 159 has to do with the prescription department. And it's getting back to what I said earlier, is that the prescription department is closed when the pharmacist is not there. And it has to have a sign on it, and it's got to be 2 inches in height. They tell you how big the letters have to be. That says prescription department closed. And so nobody can go into the prescription department when the prescription department is closed. One exception to that is the next rule on page 160, and that is what I call the meal break rule. And that says that a pharmacist can leave the pharmacy department and take a meal break that doesn't exceed 30 minutes. And in that case, pharmacy technicians can remain in the pharmacy, and the pharmacy department is not considered closed. The pharmacist still can't leave the premises, so they have to stay within the building. They can't go out to McDonald's and come back. They have to stay on the premises. And you can read about how, number 4, how technicians can remain in the pharmacy, and they can continue to do operations, but obviously they can't send out a new prescription that's come in because it's not been checked by the pharmacist yet. So, but if a prescription's already been filled and it's bagged up and it's in the will call bin and no counseling is required, we'll talk about counseling in a minute, because Florida doesn't have mandatory counseling. If they make an offer to counsel and a patient says, I don't need counseling, they could actually complete that transaction during this meal break time. Okay. The next section, I'm starting on the bottom of 160 over to 161, is about generic substitution and also biosimilar substitution. This is an area where I think that it's so commonly practiced today, and almost mandatory because of insurance companies. And I think I saw a statistic like over 85% of prescriptions that are dispensed are now generic. It's so common today that it doesn't even seem like it's that controversial or that we should have that many rules about it. But I think if you understand a little bit about the history of generic substitution, you'll see it's a little bit more complicated than you realize. And there are a lot of rules on it, and you can ask a lot of questions on it, because you have to understand that in the old days, and this is even before I was a pharmacist, even before my time, a lot of states had anti-substitution laws because there weren't a lot of generic. This is before the amendments to the Food, Drug, and Cosmetic Act made it easier to get generics on the market. There weren't a lot of generics available, and there were anti-substitution laws, so that if a physician ordered a particular brand of a product, of amoxicillin or something like that, you'd have to dispense that brand. Pharmacies, there weren't that many drugs available, I guess, back then. You'd have to have multiple brands of the same drug because there were anti-substitution laws. It's completely opposite now. Now we have a lot of states that have mandatory substitution. Insurance companies mandate if you want to get lower copays. Remember that they're not going to ask you about insurance company rules here. But I think you need to understand that history. And if you go back to the term generic products in the old days had this reputation for being inferior products. You know, if you went out and you bought, you know, generic paper towels or generic toilet paper, it was kind of like a no branded version of toilet paper that didn't do any advertising, had you know, it wasn't the fancy Charmin toilet paper. It was just like the name of it was toilet paper, and it came in black and white lettering, and it was really cheap and of lower quality. So when we started having generic drugs, a lot of people were against it because they felt like generic had this connotation that it was inferior. But obviously, with the FDA rules on what constitutes generic equivalency that we already studied, remember in the Orange Book, that it's got to be the same drug in the same dosage strength, and when you take it, it has the same effect, the same area under the curve. That's generic. So we're saying it's not inferior quality. So, and because of that, and because brand name companies obviously don't want generic substitution, over the years, there's been fights over, you know, which drugs can be substituted and which ones can't. And you'll see some remnants of that in the Florida law, because Florida still has what's called a negative formulary of drugs you cannot substitute. Technically, Florida has mandatory substitution if the drug is on your positive formulary. So every pharmacy has to have a positive formulary saying, these are drugs that I'm going to substitute generic products for. It seems ridiculous to me, because to me, if you've got a generic available and it's AB rated in the Orange Book, why would you not substitute it? But, you know, if you are like anti-substitution person, you could have a pharmacy open and say, I'm only going to have one drug on my positive formulary. Everything else I'm not going to substitute. You would not have to substitute any generics. You wouldn't have a pharmacy very long, because nobody would come to your pharmacy because the brand name products are too expensive. But if you have a drug on your positive formulary, and your positive formulary might just say, we recognize any drug that's in the FDA Orange Book, boom, there's our positive formulary, then you do have to substitute. It is kind of mandatory, unless certain things happen, right? Number one, if it's a drug on the negative formulary, you can't substitute it. Each pharmacy doesn't create a negative formulary. There's a Florida rule that tells you these are the drugs that are on our negative formulary, and you may not substitute them. And those are listed for you on the top of page 162. Good list of things to memorize. Okay, those are the drugs that cannot be substituted generically. And there are a lot of drugs that aren't really used that often anymore. So I guess some of them are, but you need to memorize that list. Okay. There are ways that the prescriber can prohibit substitution. So even if it's on your positive formulary, you would not be able to substitute it. And what states have done over the years is they've tried to make it difficult for physicians and prescribers to prohibit substitution. And why have they done that? Well, they're trying to save money not only for the consumer, but for the government, because a lot of these prescriptions are covered by Medicare or Medicaid. Those are government plans that are paid for with tax dollars. So we want to encourage substitution and make it difficult to prohibit the substitution. So the only way to prohibit the substitution on a written prescription is by writing what I call the magic words, medically necessary, in their own handwriting. It can't even have a stamp that does it, or have the nurse or somebody write it out. It's got to be in the prescriber's own handwriting. If it's a verbal prescription, they can just pretty much say, don't substitute. And in electronic prescriptions, obviously there's a way they can do that as well, by indicating no substitution allowed. Okay. The board also has, again, when this was very controversial, we had to have a big sign to let people know, hey, we have generic drugs available, and you should talk to the pharmacist about getting a cheaper drug. And there's a sign that you have to put up, and it's got to be 1 inch in height and has specific words, and that's listed for you on page 162. Every pharmacy has to have that sign in your pharmacy. You also have to notify the patient when you generically substitute, and you have to notify them of what the price difference was. I think most pharmacies do this in writing, and also their right to refuse the substitution. There are very similar rules for biological products, but as I mentioned when we covered this in chapter 1, FDA has not yet designated, at least the time that I'm recording this, any of the biosimilar products as interchangeable yet. Once they do that, then some of the same rules that apply to generic substitution would apply to biological, interchangeable biologics. Okay, transfers of prescriptions and pharmacies having a common database. We talked a little bit about this under the controlled substance rules because there were limitations. You could only transfer one time unless they shared a common database. So what this says, and remember, only a pharmacist can do transfers. Technicians can't do the transfer, but you'll see when it's electronic, things are a little bit different. But what it says, it kind of goes through the rules of the record keeping requirements. Some of these are, again, written when everything was on paper, and it said you'd had to write void across the top of the front of the prescription and let it know, so you know that the prescription's been transferred to another pharmacy, the name of the pharmacy it's been transferred to, and so forth. A lot of this is all done electronically now, but the rules are in there for both a paper record keeping system and electronic record keeping system. And the rule even says that you can do this electronically, or you can do that verbally, transfer the prescription, and then record everything on the hard copy as well. And so like I said, on top of page 164, you have to cancel the prescription if it's either by writing the word void on it, or if it's done electronically, you just cancel it in the computer system. So there's an interesting rule here that says, we talked about if the pharmacies share a database, the transfer can go back and forth more than one times. Florida's gone an extra step here on number 2 on page 164, and says that if you're under common ownership and you share a database, that we're not even gonna call that a transfer, right? It's not considered a transfer, because you could fill a prescription that's in the database of another pharmacy that's in your system, which kind of makes sense. Why transfer it and transfer it back? If the patient happens to be somewhere else, it's all part of the same system. And I need my prescription filled when I'm somewhere else, I can get it filled without having to transfer it here, want to transfer it back. So from a practical sense, I think that makes a lot of sense. From a DEA perspective, they say it can be transferred back and forth. So I'm not sure that applies to the controlled substances or not, but for Florida purposes, that's not considered a transfer. All right. We talked about central fill already, and I guess I should probably move this section over to the central fill section. But remember that a central fill pharmacy, this is the Florida rule that allows a central fill pharmacy to deliver directly to the patient, which is not allowed for controlled substances. So we kind of covered that already. All right, on page 165, we're talking about a Florida rule. It's in the statute and it's in the rules for emergency refills. And I mentioned this way back in the controlled substance chapter when I talked about emergency filling of a verbal Schedule 2. And I said, please don't get this mixed up with emergency refills. They're two separate things, because remember, an emergency verbal Schedule 2 is not a refill. There's no refills. So this is the Florida rule I was talking about. Florida, and many states have this, allows a pharmacist in an emergency to provide a refill when there's no more refills. That's basically what the rule says. Take care of the patient, right? Right. I mean, I remember for years when I was teaching pharmacy law, before Texas, where I teach, had a law that said you could do this, and I would get questions from my students saying, what do I do if it's a Saturday night and my patient needs an anti-epileptic medicine and they're out of refills and I can't get a hold of the doctor? And I would just tell them, you know what, give them enough to get through the weekend. And they would ask me, is that legal? And I'd say, no. And they're like, oh my gosh, my law professor told me to break the law. You know, so some pharmacists were nervous about that. But like sometimes you got to do the right thing. So a lot of states have addressed this issue to encourage pharmacists to do the right thing. Now you can legally do it because it's a rule, but now you got to follow the rules. So this rule doesn't say it's specific to community pharmacies, but I put it here because that's who does refills, right? And what it says is, if you're unable to get authorization from the prescriber, you got to make a reasonable effort to try and get authorization. You can dispense a one-time emergency fill of a 72-hour supply. And if it's an insulin prescription, you can give them 1 vial. I find that interesting that they specified insulin, but nothing else. What if it's an inhaler? Can you give them 1 inhaler? I would think so. Again, take care of the patient, but that's why the rule's written. You can't do a 72-hour supply of an inhaler, but I would just give them the whole inhaler. The rule generally is if you can't get a hold of the practitioner or the prescriber to get the refill authorization, you can give a 72-hour supply. If there's an emergency order issued by the governor, proclamation, then you can get in the area where you are. So if there's a hurricane in your area and you know there's an emergency declaration, and the Board of Pharmacy will have this on their website, then you can give a 30-day supply. That's a current situation. We're in the pandemic situation we're in. 30-day supplies of refills have been authorized. The rule says it's not for Schedule II drugs. Makes perfect sense. Why? This is emergency refills. There are no refills of Schedule IIs. But it does cover Schedule 3 through 5. Now, I will say this. Does DEA allow this? They've never really addressed it. And I think because you're trying to take care of the patient and it's a 72-hour supply, answer the question according to what the Florida law says. This is one of the questions you don't want to ask DEA, right? Because if DEA came back and said, no, the law doesn't allow that, a lot of state rules on this would not be valid anymore. So this is me as a lawyer looking at it. I always wondered about that. But so, but don't let them trick you. You know, when would you want to, now would you want to do it for a Schedule 3 through 5 drug where you don't know the patient and it's a highly abused drug? And probably not, right? But if you got somebody who's on phenobarbital, right, for seizures, that's a controlled substance. That would be a good time to use the emergency refill rule. Okay. And you can see the requirements there. It's got to be, you know, it's going to result in interruption of therapy. There could be undesirable health consequences. You do have to create a new order for it to document this. And then you have to notify the prescriber after you did it. You couldn't get a hold of them. You don't have to get permission to do this. That's the whole reason you're doing it, because you couldn't get permission to do it from the prescriber. But you do have to notify them. It doesn't say how long. You have a reasonable time afterwards to notify the practitioner. What happens if the prescriber says, I didn't want them to have any more refills? Nothing. You use too bad. You should have answered the phone, doc. I mean, I get that question a lot from the students, and it's like, you know, you use your professional judgment, and you made a judgment call. So nothing's going to happen. The doc may yell at you or something like that, but nothing legally should happen to you. Okay, make sure you read the study tip. We talked about the controlled substances. Okay. Next is over 90. And this is all the records, the rules related to keeping patient medication records, performing drug utilization review, and patient counseling. So this was a law that was passed. It was a federal law, and it required for Medicaid patients. This is before Medicare had any prescription drug coverage. Back then it was only Medicaid had prescription drug coverage. And it required for Medicaid patients that pharmacists provide an offer to counsel. And the idea was, this was one of the early attempts on a federal level to get pharmacists hopefully doing and getting paid for something unrelated to just dispensing the drug. And that was for counseling the patient and for monitoring for drug interactions. And the idea, the reason it was done as part of this Medicaid law, was to try to save Medicaid money. And the idea was that if you get pharmacists to do this, they will identify drug interactions and drug inappropriate use, clinical abuse and misuse, and they will prevent patient harm, and they will prevent hospitalizations, and overall the cost of the Medicaid program is going to go down. Unfortunately, it was passed, but it didn't provide for compensation to the pharmacist to do this. It was passed with some pilot projects that said, okay, we're going to have pharmacists do this, and they did a couple of pilot projects to show that it's actually saved money, and they did that, but they've never been able to pass the part that says, you know, pharmacists must do this and must get paid for it. We're getting better, right? And if we get provider status, maybe we can do that. But you know, certain insurance companies now will pay, and there is payment now, obviously for MTM. Under the Medicare laws. So, but this was the early part of when that started, right? So to make sure you understand the history. So what it requires is that you keep a patient record, a patient profile is what we used to call it. And here's the rule for that. You must have a patient record system. And what it says is you must make a reasonable effort to obtain and record the following information. I think you need to know that list. I mean, I guess technically, if you don't have everything in the profile on this list, if you can show you made a reasonable effort to get it, then I would say you're in compliance with the law. These records have to be kept for 4 years. And you have to perform a prospective drug use review on page 156. So this is every time you fill a prescription, both new and refill, and you have to look for certain things. And these are things that are in the federal law. Florida just copied the law, the rule language here: therapeutic duplication, drug interactions, incorrect drug dosage, drug allergies, clinical abuse and misuse. And then obviously, if you find one of those things, you have to try to resolve the potential issue by contacting the prescriber. And then we move to the other part of this federal law, which required the offer to counsel. And you know, many states said, okay, we're not going to make this just for Medicaid patients. Doesn't make sense. Why should they get, you know, mandatory patient counseling or offers to counsel? Shouldn't all patients get that? And that's what Florida did. It's for all patients now, not just Medicaid patients. But it still is, if you read the language, a verbal and printed offer to counsel in Florida. So it is an offer to counsel. It's not mandatory counseling, even though if you read the definition of dispense, it says a pharmacist shall counsel the patient if the pharmacist's professional judgment believes it's necessary. So they don't quite go together. If you think it's necessary, then you have to do it. But for all patients, you have to at least offer it. And the offer has to be verbal and printed on top of page 167. And you have to have a separate area in your pharmacy that's designated for private consultation. And remember, it's new prescriptions and refill prescriptions. Other states do it differently. Some states have mandatory counseling for new and only offers for refills. Some have mandatory for, I don't know if anybody's got mandatory for both, but just realize for Florida, it's an offer for new and for refill. And it's both printed and verbal. If you deliver your prescriptions, you don't have to do the verbal offer. You only have to do the written offer. And then are there mandatory things you have to counsel about? No, people think there are because there's a list in here. But if you read the rule carefully in letter E, it says, what you counsel about is up to you, the pharmacist. But it may include the following. To me, I don't think why even have a rule if it says you may do something? So, but anyway, so you don't have to go through all these things. But you know, if you think the only important thing to counsel them all on is make sure you take all this medication, all 10 days worth, that's all you have to do. Okay. Obviously, if a patient refuses counseling, you don't have to provide it. On the bottom page 167. A lot of states say you have to have documentation of refusals to accept counseling. I didn't see that Florida specifically required any particular documentation of that. All right, turning over to 168, we got a rule for automated pharmacy systems. You can read this. You have to have a policy and procedure manual if you're going to use an automated system. This could be an automated system that does automated dispensing. It could just be the automated counting, like a Baker cell machine, or it could be a completely automated system that automates the entire dispensing process. Just make sure if you have one of these systems that you have a policy and procedure manual, and it covers all the things listed in number 3, A through F. On page 168. when you close a pharmacy, this is the rule when you close a pharmacy. And again, this is the rule didn't say it was just for community pharmacies, but I put it in this part of the book because it's talking about the prescription files and who else is going to have prescription files, but a community pharmacy that's doing outpatient dispensing. So just realize that you have to notify the board of pharmacy before you're going to close, and let them know where the prescriptions are going to be transferred to. You can't simply just shut down a pharmacy because patients have refills and they need to know where they can get their refills. So if you close a pharmacy, those files, your prescription files, have to be transferred to another pharmacy so patients know where they can go to get their refills. That's basically what this rule is trying to take care of. To miscellaneous community pharmacy rules on 169, I mentioned this when we did controlled substances. There's language that says only community pharmacies can dispense Schedule 2 or 3 controlled substances. Again, that was tried to eliminate physician dispensing of Schedule 2 and Schedule 3 controlled substances. There are a couple of exceptions where physicians can do it. For the most part, though, only community pharmacies can do that. You can read through the fax prescriptions. It basically just says that if a patient faxes you a prescription, you can prepare it and get it ready, but until they bring in the actual written prescription and you verify that it wasn't one that they made up themselves, you can't really dispense it to them and give it to them until you get the actual written prescription. If a fax is coming from a physician's office, then remember, you treat that like a verbal prescription. You can fill it. You don't have to get the original one. But this is talking about getting a fax order sent by the patient, so it's a little bit different. Unclaimed prescriptions. This is a rule that says, like, what happens if you prepare a prescription, put it in the will call bin, the patient never picks it up? Can you then redispense that drug? And the answer is yes, because it never left your control. So if the patient never picked it up from the will call bin, you can take the drug back and put it back on the shelf. It's not recommended you pour it back into the manufacturer's bottle, because now you could be commingling different lot numbers, and that's something you don't want to do. You could be adulterating the bottles. So the best recommendation is to put it back on the shelf, and I would recommend removing the label or at least removing the patient name from the label, so there's no PHI for HIPAA reasons sitting on the shelf there, but maintaining the name of the prescription drug and the date, because remember, you got 1 year from the date it was dispensed before it has to be used. Or if the original date from the original manufacturer's bottle was less than a year, you get that date. So it's always 1 year, a maximum of 1 year, or the original date from the manufacturer's bottle if it's less than a year. Okay. There's also a rule that gives you certain rights for Medicaid audits and pharmacy audit rights on page 170. I'll let you read through that. That's kind of an interesting one, because normally the boards of pharmacies are not involved with reimbursement issues, and unless there's fraud going on by the pharmacy. But this is helpful, though, because it's a statute that gives you specific rights if you're audited by Medicare or Medicaid or a PBM, and they're trying to get recoupment of some of your monies they paid you. It provides you some certain rights, which is helpful when you're trying to fight these things. All right, now we're going to start with institutional pharmacies. Okay, so for institutional pharmacies, and we talked about how many types there were in the last chapter: class 1, class 2, class 3. And we mentioned that they have to have a consultant pharmacist of record, and remember, they have to have special, an additional license for that. So all institutional permits have to have a consultant pharmacist of record. It's the equivalent of the prescription department manager in a community pharmacy. A consultant pharmacist for a nursing home or facility like that must actually perform drug regimen review and visit the nursing home facility at least on a monthly basis. That's a federal law as well, but it's also in the Florida rules on page 170. Here's the labeling requirements for when you got patients in a nursing home. And you'll see they're a little bit different than the community pharmacy labeling requirements. So you want to study these and make sure you know the differences. It might be helpful actually if you had a chart that shows the labeling requirements of community pharmacy, maybe for customized medication packages, and then also for ones in nursing homes. If you're going to label repackage or unit dose products, and a lot of institutions use unit dose, right? Or if you're in a nursing home situation, you might use blister packages or something like that. Separate labeling requirements for those where you put the name of the drug, the strength, the dosage form, the manufacturer, expiration date, and then either the lot number of the manufacturer's bottle, or most pharmacies create their own lot numbers. What this allows you to do if you're using unit dose or repackaged drugs is it gets you out of having the name of the patient, the name of the prescriber, the prescription number, all that information, because in that situation, all that information can be kept in the medication administration record of the facility. So it allows you to use unit dose or blister packages or things like that without having all the specific prescription information on the actual label. If you are going to prepackage medications for use in institutions, these are the rules for that on page 171. And you have to assign a lot number to it and so forth. And we talked a little bit about this closed system, this closed drug delivery system. And I mentioned that if you get a closed door pharmacy permit, one of the advantages to that is it allows you to take drugs back from those institutions and possibly redispense them. Here's the rule that does that. So if you've got a closed drug delivery system, and notice what it says in 5A, it's where actual control of the unit dose and customized patient medication packages are maintained by the facility. So the patient doesn't have access to it. The facility has access to it. Then any unit dose or customized packages that went to the facility may be returned to the pharmacy for redispensing if they're sealed, and you can tell they've not been tampered with, obviously. So the study tip there, I think, helps you with that. Remember, normally if a drug is dispensed out of your pharmacy, you can't take it back and redispense it. This is an exception to that rule. DEA does not allow this for controlled substances, but for non-controlled substances, Florida does allow this. And it's really to minimize waste and drugs that go out to these facilities and these nursing homes. All right, if we turn to 172, we're talking about starter dose prescriptions. And what is that? Well, this is kind of a convenience thing again as well. And I'll let you read through the details on this, but what it's saying is if you're a pharmacy and you service a nursing home, but that nursing home that you service is, and it doesn't have to be a nursing home, class 1 nursing home, it could be also a modified class 2B, which is maybe a different type of facility. But you can't get the initial dose to that patient right away. You can contract with another pharmacy that's closer to that facility to provide the starter dose or the first dose for you. It's a really convenient thing because if you've got a patient in a nursing home and they need, let's say, an antibiotic, and you can't get it to them until 48 hours after the order, that's not going to be helpful to them. So it allows the first dose to come from a local pharmacy that's close, and they get it to them quicker, because your facility may be in another city. My mom's in assisted living in Houston. Her pharmacy that services that facility is actually in Dallas. And I've run into this problem before. We don't have this rule in Texas. It would be helpful if we did, because so if she needs something right away, I have to get it filled locally and bring it over there, because we don't have this rule. So what this does is the vendor pharmacy is the pharmacy that's servicing that nursing home. They can contract with another pharmacy to provide the starter dose. Okay, and they can't do this for controlled substances, again, because it creates problems with DEA. But you can read through that rule. It's a really good rule, I think, to help patients get their therapy started quicker in these nursing homes and assisted living facilities. All right. 172 bottom, class 2 and class 3, which, remember, that's hospital, right? Class 2 is a hospital, and class 3 is a hospital that wants to do some centralized distribution of prepackaged drugs. What this says is that A person who can prescribe in a hospital can also, the hospital can actually dispense a 24-hour supply to patients that came into the emergency room. And this is, again, for convenience purposes. When a patient's discharged from the emergency room, they can always write a prescription for that patient. But if they get discharged in the middle of the night and there's no pharmacy, community pharmacy that's open 24 hours around that area, the patient needs to get access to that drug. So it allows the emergency room to dispense a 24-hour supply. The pharmacist of the hospital, the Class 2 permit, and I guess the consultant pharmacist of record, is responsible for making sure we got records of this, and that's listed for you on 173. And the records have to contain the information listed there in B 1 through 7, including number 7, the reason why community pharmacy services are not accessible. We don't want the hospital emergency room competing with the local pharmacies, right? So this is only done for 24 hours until they can get the prescription filled that they got from the emergency room. So that's all that rule is trying to say. Okay, automated distribution and packaging. This is for use in hospitals. This is for things like either packaging in a hospital pharmacy, or more likely it's automated dispensing machines like Pyxis machines that you see in hospitals. So these are the rules related to that. Make sure you read the responsibilities of the consultant pharmacist of record. You have to have quality assurance program and procedures for stocking and restocking, packaging, controlling access to the system, and so forth. And then if you turn over to 174, Florida's done a really nice job here, I think, of saying, okay, look, for drugs that are in a automated dispensing machine in a hospital, we still want pharmacists to provide prospective drug use review. In other words, you want the pharmacist to look at the order, make sure there's no drug interactions, proper dosage, and so forth, and it's on the formulary, all those types of things. And then they authorize the nurse to take the medication out of the automated dispensing machine, but not until the pharmacist has reviewed the order. Well, that works in most cases, but what do you do in a situation where you're in an area of the hospital and they need the drug right away? And you can't get a pharmacist to review the order first? So they cover that with 3 different categories. They call them override medications, low risk override medications, and physician controlled medications. The example I gave you, if you're in an area of the hospital where a physician is making the order and the pharmacist is not available, that would be like in an emergency room or the operating room or the recovery room. They may have an automated system in there. You're not going to wait for the pharmacist to review the order when in those situations. It's physician controlled. So you don't have to have prospective drug use review for a physician-controlled medication in the hospital. But even outside of those physician-controlled areas, what it says is the hospital can designate override medications where we don't want to have significant delay in a patient getting the medication, or just low-risk medications that, there's not really going to be any drug interactions with this type of drug, that we're going to allow the nurse to access the drugs out of the automated system before the pharmacist does the drug use review. So you read through that section, I think it kind of makes sense for you. But you do have to do retrospective or after the fact drug use review, even for those drugs that have these exceptions that allow the nurses to take the drugs out of the system. These Pyxis machines or automated dispensing machines that are in hospitals, notice the number F, it says they can't allow access to multiple drugs. That's to prevent diversion. So some of these systems, when they first came out, when the nurse put the name of the drug in that they wanted and the pharmacist approved it, but the drawer would open up, not only the drug that they wanted was available, but it was called a matrix drawer, and you could get access to anything. Florida said, no, you can't do that. It only has, it has to allow only access to the drug that the nurse is trying to get out of the system. Okay. Oh, I'm sorry. That's only for controlled substances, which makes sense. You're trying to prevent diversion. So you can have a matrix drawer or open drawer if it's a non-controlled substance, but for controlled substances, they have to only give them access to that particular drug, which makes perfect sense because those are the drugs you're trying to prevent the diversion of. Okay, those rules are for what we call like decentralized automated systems, because they're decentralized means they're not in the pharmacy department, they're out on the nursing units or in the emergency room or the operating room. That's a decentralized automated system. Letter G on the other side, and going over to 174 to 175, is about a centralized automated system. So that's where the system is inside the pharmacy, and doing some type of automated process within the pharmacy system. It could be automated compounding or something like that, or automated preparation to go into the other systems. But a slight difference here between the decentralized system and the centralized automated systems. Okay. Sorry, I was behind on the slides there. Okay, so then we got emergency room we talked about. We talked about automated distribution and packaging, and the override medications. Next, we're going to talk about on page 175, remote medication order processing. So what this allows is for a hospital pharmacy that may not be open 24 hours a day, if a new order comes in for a patient, it allows them to have someone remotely access the hospital pharmacy computer system. They'll get a copy of the order, maybe from a fax or electronically somehow, and they can remotely access the hospital's computer system, do that prospective drug use review, check for drug interactions, check for any potential problems with this prescription, this order, prescription order, enter it into the hospital pharmacy's computer system, and then authorize the nurse to take the drug out of the automated system. Or if they don't even have an automated system, it could authorize the nurse to go ahead and get a drug out of the pharmacy. Remember, they can take one dose when the pharmacy is closed, but at least they got the comfort of knowing, hey, a pharmacist has reviewed this, there should be no orders with it being the wrong dose or a drug interaction or something like that. So it's a good way to supplement a hospital pharmacy that may not have 24-hour services. They can outsource the review of orders and the order entry to another pharmacy. It could be another hospital pharmacy that does have 24-hour services, or it could be a different company that just provides this service. Cardinal Health is what we have, a company that does this. We have medication order processing pharmacists who sit in an office building somewhere, and they enter orders for hospitals, throughout the country in different states. All right. One thing to realize is Florida does require, if the remote processing is done from out of state, they do require the pharmacist that's doing that processing to be licensed in Florida. They don't require that for like a mail order pharmacy who's shipping into Florida, but if you're accessing the hospital's computer system from out of state, and reviewing those orders and entering those orders into the system, it does require that the pharmacist be licensed in the state. Okay. Emergency medication kits in the nursing home. We talked a little bit about this in the controlled substance chapter. Most states allow a pharmacy to place an emergency medication kit in a nursing home. So these are drugs that are not patient specific, they're not labeled for a particular patient, but if there's an emergency and a patient in a nursing home needs access to, let's say, a Valium injection because somebody's having a seizure, you want to have that available to them, even though they have to have, the doctor can order it, but you don't want to wait for the pharmacy to deliver it to the nursing home, right? That's why you have these emergency medication kits. Some states set limits on the types of drugs that can go in emergency medication kits or the quantities of drugs that can go to emergency medication kit. Florida doesn't do that. What it says in number 3, we don't have a specification on that, but number 4 says the facility medical director and the director of nursing and the consultant pharmacist for that facility can determine what goes in there. And it can have controlled substances in it. Remember back to the controlled substance chapter, that's really the only time DEA allows drugs that have not yet been dispensed to be stored at an off-site location that's not a DEA registrant. So if you have a tackle box with controlled substances in an emergency medication kit in a nursing home, DEA says that's okay, as long as it's just a tackle box. They make a distinction though, DEA does. If you're using an automated dispensing machine as your emergency kit, then they do require DEA registration. So don't forget that from the previous chapter. I put the study tip there. Okay. To kind of go along with that, this is the rule on 176 and over 177 is, what if we want to put a Pyxis machine or an automated system in a nursing home, long-term care facility, or a hospice? It also allows it in prisons. And this was a rule that was passed to first allow that, because remember, normally drugs being sent to a nursing home are dispensed, and they're dispensed to the patient. They might be in unit dose, and you might have alternative labeling, and if it's a closed door system, you might be able to return those drugs. But wouldn't it make a lot more sense if we treated the nursing home like a hospital, and they could just have unit dose medications inside an automated dispensing machine that aren't labeled for anybody? That's what this rule did. This rule was passed. I actually helped work on this rule years ago when Cardinal used to own Pyxis. I spent a lot of early part of my career, I was out getting automation regulations passed, and this is the one we got passed in Florida, actually. I remember doing this. So it allowed basically putting an automated system in a nursing home. And you can see the language in there about how this works. And remember that the key here is in the study tip is that if you're going to keep controlled substances in one of these automated systems, either to dispense all regular drugs or as a emergency kit, or for both. A lot of nursing homes use it for both. It does require a separate DEA registration. And make sure you read about who can restock the drugs. What they said was a pharmacist has to restock the medication, or if the system uses removable pockets or drawers, where you could fill these pockets or drawers at the pharmacy and then they're placed into the system, then a pharmacist doesn't have to go out to the facility to do it. So the technology that actually we came up with back then was, we had these little cubicles, and they had electronic sensors in them, and you could fill the cubicles with the unit dose medications in the pharmacy, and then deliver them to the nursing home, and you could authorize a nurse or someone to place it into this. And once you put it into the machine, it reads it and knows what's in that particular cubicle. So that was helpful, because if you're just using an open drawer, they required a pharmacist to do it, which wasn't practical to send the pharmacist out there to restock the system. Okay. That's it for the institutional pharmacies. A real quick thing on nuclear pharmacies, just realize nuclear pharmacies is a very different type of practice. Nuclear pharmacists have to have 200 additional hours of didactic or classroom training, and then an extra 500 hours of internship, at least 500 hours of internship to get their license. And then in addition to the 30 hours of continuing education, on page 178, they got to do an additional 24 hours of nuclear pharmacy CE. So just like consultant pharmacists have an additional 24 hours of consultant pharmacist recertification, nuclear pharmacists have an additional 24 hours of basically, it's not recertification, but it has to be continuing education related to nuclear topics. Okay. I would read the definition of a nuclear pharmacy. One thing interesting about nuclear pharmacy is that number 7 on page 178, B7, sometimes if it's a diagnostic radiopharmaceutical, it can be used for diagnostic purposes, which a lot of the nuclear radiopharmaceuticals are. They can actually dispense it without having the patient's name. It can just say physician's use only. And because sometimes the nuclear medicine of a hospital will call up the nuclear pharmacy and say, hey, we have an 8 a.m. Cardiac procedure, and we need a dose, and they don't even have the patient's name yet. So they allow that. And remember, they also allow the pharmacy technician to take verbal orders for these diagnostic radiopharmaceuticals. So a little bit different labeling requirements when it's for a diagnostic. If it's for therapeutic purposes, and they're actually treating something with the drug that's being dispensed. And they do what's called radiopharmaceutical tagging of blood products, where blood products are sent to the nuclear pharmacy, and they put a radiopharmaceutical marker on it. That is that, and also therapeutic radiopharmaceuticals have to be, verbal orders for those have to be taken by the pharmacist, and those have to have an actual patient name on them. So only the diagnostic ones don't have to have a patient name. Realize there's an inner container and an outer container, because these are radioactive drugs, right? And they're decaying. So there has to be a lead shield that they're transported in. And so the outer container has to have a label on page 178, number 8, A through P. And then once you remove that outer container, there's an inner container that's got less information on it. It just has the radiation symbol, radioactive material, and so forth. I told you we got rid of all the space and counter space requirements. They haven't done that for nuclear pharmacy yet. So I did notice they do have a minimum square feetage requirement of a nuclear pharmacy. I would hope they wouldn't ask you that, but if they do, it's 150 square feet. Okay. Chapter 5 is disciplinary actions and procedures, and then a couple of miscellaneous laws, and I'm going to go through those rather quickly. First of all, you need to realize that the Board of Pharmacy does have the authority to go in and inspect. And it says agents or employees of the department. Here, we got to remember, the department is the Florida Department of Health. So the inspectors technically work for the Florida Department of Health. But remember, the Board of Pharmacy is part of the Florida Department of Health. So don't let them confuse you with the terminology there. And they're looking for, you should know what they can do. They can make sure you're in compliance with the laws. Can they take samples out of your pharmacy? Yes, they can. But they have to pay or offer to pay for those samples, which I found kind of interesting. And if it's a controlled substance, you definitely need to get a record of it if they take any controlled substances. When you apply for a license, there's grounds for them refusing your license are the same grounds that they can discipline a license for. So you can read through the list of things on the bottom of 183, going over to 184, 185. These are all things that the department can take action against your license, getting your license by fraud, trying to get the license for somebody else, being unfit or incompetent to practice pharmacy because you are intoxicated, habitually intoxicated, or you're misusing or abusing controlled substances, kind of normal things you would think that a Board of Pharmacy could discipline you for. Number 6, if you've been convicted of or found guilty of, regardless of adjudication of a crime that directly relates to the ability to practice pharmacy. And this is important because it says, if you plead no contest to a crime, if it directly relates to the ability to practice pharmacy, and I would say that would include things like anything to do with substance abuse or even a DUI or something like that. If it's considered a crime, and it could be, even if you plead no contest, and a no contest plea simply means that you're saying, I'm not pleading innocent or guilty, but I'm pleading no contest, and you go to deferred adjudication or probation, and after you finish your probation, the charges are dropped. You can do that for the criminal charges, but what the Board of Pharmacy is saying is that they're going to consider a no contest plea as a conviction. So they can still take action against your license for things like a DUI and things like that. So even if you plead no contest. So just be careful you get to a situation. Make sure if you're ever involved with something that's a criminal violation, if you have an attorney representing you, make sure they know that, look, I'm a professional, I have a license, and anything that you do, they're worried about keeping you out of jail or whatever, but it can also impact your license as well. So make sure they don't forget about that. Okay. I'll let you read through all these other ones. I think it's important, number 15 on the bottom of 184, if you fail to report to the department, because remember the department also licenses under the Board of Medicine physicians. This one's interesting. if you know a physician who has violated the grounds for disciplinary action set out under their laws. First of all, you'd have to know what their laws are, but and they provide healthcare services in a facility like a hospital where you also provide services. So like if you know you got a bad doctor basically in your hospital that's violating some provisions of the medical board, or they can't practice safely because they've got some drug addiction or something like that, um, you you have to notify the department of that. And if you don't do it, failure to report that is a violation on your part. So yeah, I think if you know something like that of a physician in your facility, you got to bring that up to the management of the pharmacy and the hospital. I would document what I do, and you might even, if you want to follow this strictly, report it yourself directly to the department. Okay. Um, I didn't see a mandatory reporting one of pharmacy technicians or other pharmacists. It's interesting, you got this one for physicians, but I put in the study tip there. I couldn't find a mandatory reporting requirement if you have a pharmacist or a technician who's impaired. Um, I didn't see a requirement you mandatorily report that to the department. So what you should do in that case is refer that individual to the Florida Professional Recovery Network and hopefully get them treatment. And there's more information about the Florida Pharmacy Recovery Network available in the study tip I gave you there on page 185. Notice number 16 on 185, within 20 days, you have to report to the Board of Pharmacy in writing if you stop practicing because of disciplinary action in another state or investigation in another jurisdiction. So if you're licensed in Florida, but you live out of state, you get disciplined in another state, make sure you notify the Board of Pharmacy about that, particularly if it involves stopping practicing. All right. And you'll see committing an error is one number 20 on page 185. So you see a lot of misfilled prescriptions or disciplinary cases quite often with the Board of Pharmacy. And then if you go to the statute on page 186, letter C, other violations, okay, a lot of those that we had listed there are grounds for discipline. And then in 465.015 of the statute, there are other violations, and a lot of these some of these are also criminal violations, but just realize that there could be criminal action taken by the state against you, but also the Board of Pharmacy can take action for these types of violations as well. And this is about making false or fraudulent statements to the board, filling prescriptions or dispensing prescriptions if you're not licensed as a pharmacist, selling samples. We talked about way back in chapter 1. This is all in letter number 2 on page 186. Illegally using the word pharmacist when you're not, or druggist when you're not technically licensed as a pharmacist or druggist, that's illegal. Number 5 even says you can't, companies and other businesses can't use the term RX or apothecary unless they're a pharmacy. I always find that one interesting. I've seen businesses around here that use that term, and they're like furniture repair apothecary or RX, and they don't know that they're violating the pharmacy rules, but they are. All right, 187, board action on pharmacy permit applications. This one's important, I think, because what it says in D1 is the department or the board shall deny an application for a pharmacy permit. Doesn't say they may or they can. They have to deny it. Okay. If the applicant has committed misrepresentation or fraud, have attempted to procure or get the license by false representation, if they've been convicted or pleaded no contest to a crime in any other jurisdiction related to the practice of pharmacy. So it's pretty strict rules, and it's all kinds of other ones, D, E, F, G, H, I, J, you can read on page 188, where they have to deny the application. All right, let's talk a little bit about what type of disciplinary actions there are on page 189. The department or the board can revoke your license, they can suspend your license, and they can also fine your license. So revoking your license means your license is gone. That's the most severe one. A suspension of a license means you're suspended for a specific time period. You're suspended for 6 months. That means you can't practice for 6 months. So they might suspend your license, but instead put you on probation that says, okay, during the probation, because they know you need to work to pay your bills and things like that. So they might technically suspend a license, but put you on probation. And that's why it says they can place you on probation or a fine or otherwise discipline your license. And they could do these things together. They could suspend your license with a fine as well. And you'll see that a lot if you look at some of the actions that have been taken by the board, by the Board of Pharmacy against pharmacists. Okay. There are disciplinary guidelines that the board has on page 190, and it's a really long list of what they generally intend to do in specific disciplinary cases. I would never think they would ask you that because there's no way you'd be able to memorize this list, but it's a comprehensive list of the penalties they're going to impose. Like if you didn't have your continuing education, we're going to fine you this much. If you didn't consult the PDMP when you're supposed to, we're going to fine you this much. It's kind of things like that, right? So it just kind of gives you guidelines because they want to try and treat everyone fairly and treat everyone the same. Otherwise, they could get into trouble if they do that. So I don't think you need to know the specifics of that, but just realize they're only guidelines. So what you'll see on the bottom of 190 and top of page 191, if they've got aggravating circumstances, they can go above the guideline. So aggravating circumstances mean things that, well, there was harm to the patient. They can look at the amount of harm that was caused, or the scope of the damage that was caused. So they can go above the guidelines if they can show there were aggravating circumstances to increase the amount of the penalty or the sanction that's imposed. And number 4 on page 181, if they can show that there were mitigating circumstances, they do the opposite. They said that, well, if there was stuff that we can go below what the guidelines say. Normally we give a $5,000 fine, but since this was their first time, they've never been disciplined. They've been licensed for 20 years, and they made restitution to whoever was harmed. Will reduce the penalty. So they can reduce it, or if there's mitigating circumstances, or they can increase it if there's aggravating circumstances. On page 191. I realize I got 2 letter F, so that probably should be letter G, but there's minor violations. For minor violations, the board can issue what's called a notice of non-compliance. This is really helpful because, for any technical violation, they could institute disciplinary action against your license. You don't want disciplinary action against your license for a minor violation. So if the violation that they find falls into these categories, you don't have the generic sign displayed. That's a minor violation. They can issue a notice of a deficiency. They call them notice of deficiencies. The statute calls it notice of non-compliance. You don't have the generic substitution sign in your pharmacy. You're supposed to have it. That's great. I can tell you a story from years ago before they had this rule. I had one of the pharmacies we had, and it was in Florida. I actually had to pay a $500 fine because we didn't have the sign up, which was ridiculous because it was a closed door pharmacy. It didn't make any sense, but that's how ridiculous the rules were being enforced back then. So this is an improvement over that. So, but you should know the list of things that are in the minor violations, and these are not considered disciplinary action. So you can just basically correct these things with a notice of non-compliance, notice of deficiencies, as the Board of Pharmacy calls them. And then they added another thing they can do. They can do citations. Citations are like tickets. And for these citation violations, you can get a ticket, and that's also not considered disciplinary action. With a ticket, though, you may have to pay a fine. So this is really, really helpful because, I mean, it's not helpful if you get one, I guess, but you really don't want to have disciplinary action taken against your license. But these are a little bit more serious, I think, than the minor violations. But if it's your first offense on these, you might be able to get by with a citation or a ticket. And notice a lot of them say, first time failure to consult the PDMP and things like that, not getting the identification of the person picking up controlled substances. Remember, it's kind of a complicated rule for that. Um, for first-time offenses of any of these things, you might be able to get by with a citation. They're not minor violations, um, but they're also not serious enough if it's your first time that we're going to start disciplinary action, because you don't want to start disciplinary action and go through that formal process for every single violation that the inspectors find when they're looking at your pharmacy. I put an overview of the disciplinary process for you on page 194. I'll let you read through that. Just realize that you can read through that. It's pretty self-explanatory. There is something called a probable cause panel, which is 2 Board of Pharmacy members serve on a probable cause panel, and that panel has to find that there's probable cause to go forth with the discipline. They could dismiss, the inspectors or the investigators for the department could have found a serious violation, and they could take it to this probable cause committee, and the two board members serving on that committee say, no, we don't really find probable cause here, and they can dismiss the complaint, and there'll be no disciplinary action. If they don't close the case, the complaint, then they file the complaint, and then you have 21 days to respond to the complaint. And you'll see when that complaint then it goes to the Board of Pharmacy for discipline, whoever the 2 pharmacists who served on the probable cause committee are not allowed to vote on the discipline for that. They are recused from voting in that case. So you'll see that happen if you attend a Florida Board of Pharmacy meeting. The 2 members who are on the probable cause panel will not vote on the discipline for that particular case. All right, so that's a good overview of the disciplinary process. And I then have a couple of miscellaneous rules I want to go over. Administration of antipsychotic medications by injection is something that's in the Florida Pharmacy Act. I didn't know where to put it, so I put it under miscellaneous rules. You can read through that. Dispensing practitioner. Florida doesn't make it illegal for physicians to dispense drugs. Remember, they can't do Schedule 2s and 3s except in limited circumstances. But what Florida says, if you're going to do it, you got to comply with all the laws that a pharmacy would have to comply with. So they try and make it difficult to try to discourage doctors from prescribing. And you can see the rules for that. And on top of page 196, again, they can't do Schedule 2 or Schedule 3s. And here's the exceptions to that, where the doctors who can do Schedule 2s and 3s. I don't think they would get into that, but you never know, they could. All right, and then finally, there's sales of syringes and needles. You don't have to have a prescription to sell syringes and needles as long as the person is 18 years of age or older in Florida. If they're under 18, you would have to have a prescription to sell syringes or needles. There was a law passed in 2019 that does allow needle exchange programs. It's really not part of the Pharmacy Act, so I don't think they would ask you on that. But when I was researching this, I did come across that when I was looking up the needles and syringes, and that's for you. I have that for you on page 197. All right, what I did in the very last chapter was I was kind of overwhelmed with the amount of laws and rules in Florida that had a day's supply limit. You could do a 24-hour supply or a 72-hour supply or a 7-day supply or a 14-day supply on this or a 34-day supply. So I tried to put all that information together in a nice study chart for you. And you'll see that on page 201. And what I did was I gave you where it's applicable to in the first column, what the limit is, and then the actual rule, if you want to look at the rules. Some of them are in the rules, the reference, some of them are in the statute, some are in the Controlled Substance Act, some are in the Pharmacy Act, some are in the Board of Pharmacy rules. But I kind of put them in order so you can see them, because these would all make great questions as far as ranking things by the time limit allowed. And it can get very confusing, right? Because there's so many of these. So that's on page 201. And then on 202, these are a summary of notification requirements and the time limit of when you have to notify by or do things by. And a lot of these are within 24 hours, within 48 hours, within 72 hours, 7 days, 10 days, 30 days. So these have all been put into place from all the stuff that we've covered in this course. And I think that'd be a good study guide for you. One of these is deleted, however, in the update document. That was, remember I mentioned about getting permission from DEA to destroy drugs with Form 41. Used to be required to do that 2 weeks prior on page 203. That's been eliminated. So you will see that in the update document. And then finally, there are self-assessment questions, 50 questions for you. I call them self-assessment questions. I don't want to call them practice questions because I'm very adamant to let you know, as you've seen throughout this course, I don't know what the questions are on the MPJE, so I can't tell you these questions are going to be similar to the ones on the MPJE. I made them more to make sure you understood the information in this book, but I did include some that are select all that apply and a couple that are rank these things in order. So at least the format of the questions will be similar to the MPJE. Hopefully these will be helpful to you. So those are the 3 things in this chapter: the day supply limitations, notification and time limit requirements, and 50 self-assessment questions. If you find these helpful, please let me know. You can always send me a note on our website. There's a contact us form. I'm thinking, you know, as I do more editions of this book, I may add some additional charts and study guides like that, because they seem to become very handy for students when I do stuff like that. And with that, this course is over. I want to wish you the best of luck. A little bit of life advice to you: get out and explore the world. This is one of my favorite quotes from Mark Twain, and it's about travel. It's also about prejudice and bigotry. And one of my favorite things to do in life is something I can't do right now during the pandemic, is that get out and travel and see the world. And I encourage you to do the same, because when you do that, you learn about other cultures and other people. And then the more you do that, the more less likely you are to be prejudiced and narrow-minded. And so I just love this quote from Mark Twain. So best of luck to you. I hope you've enjoyed this course, and thank you for participating.